everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I wanted to talk about discovery, and specifically the preliminary conference order, and then the way that defense lawyers ask for information from you, from the injury victim, and try to get your case dismissed. And unfortunately, the way that plaintiff's attorneys, the attorneys representing personal injury victims, often fail to have a discovery plan and fail to get what needs to be obtained in order to win the case. So let's get into it. And it just prompted this video. I'm just doing it off the cuff. It just kind of prompted me because I was actually doing a consultation with one of my viewers, one of my YouTube viewers. They texted me and they had a question. And I thought it was an interesting question. And I said, look, I'll get on the phone. I'll call you later today. But before I call you, give me your name and I'll look it up on the court's computer just to get a little background information so our consultation is more meaningful. And they did that. And then I was looking at it and immediately I saw the preliminary conference order because they already have a lawyer. The lawsuit was filed and there was a preliminary conference order, which basically means that both sides, the plaintiff's attorney and the defense attorney, went into court and they filled out a court order that the judge just they have a pre-printed form. The judge doesn't usually get involved with that, but they just kind of look it over and the judge just rubber stamps it. And that becomes the scheduling order for the case. So the plaintiff, the person that's suing, has to give documents to the defendant, for example, like authorizations for medical records if they're claiming an injury, right? And then the defendant has to give information or documents to the plaintiff. For example, if it's a slip and fall case, you might want to get the cleaning logs or the cleaning schedule or photographs or video surveillance of the person falling. If it's a car crash, you'd want to get photos of the cars, the property damage estimate, things like that. So basically, you're getting documents, both sides are getting documents, and then both sides are also going to do depositions. So when the plaintiff is produced and prepared for a deposition, the defendant's going to question them and ask, like, how did your incident happen? What are your injuries? What are certain things you used to do that you can't do now? And in the same vein, when the plaintiff's attorney questions the defendant will produce someone. Like, for example, in a slip and fall, they'll produce a maintenance worker and we'll ask them questions like, where were you on the date of the incident? Were you mopping? What are your procedures? How do you mop? Things like that to show that they created an unsafe condition. So anyway, so this order has everything pre-printed already, right? So it'll have things like appearances of counsel, insurance coverage, bills of particulars, which are questions that they ask, like your name, what did we do wrong, the negligence paragraph, what are your injuries, medical reports and authorizations to be served, physical examinations, which are what they call the independent medical exam, but it's really a defense medical exam to be scheduled, depositions, and then it'll have an additional directive. And that basically is just like, blank piece of paper, like a notebook, and you can write in whatever you want. So look what happened here. The plaintiff's attorney didn't write anything, right? They don't need anything from the defendant, but they're the ones who have the burden of proof. They have to prove their case, and yet they didn't write in anything, right? And the defense lawyer wrote in 6 or 7 things that they want from the plaintiff. And they wrote in things like plaintiff to provide Aaron's authorizations. Now, what that means is that if you provide an Aaron's authorization, now the defense lawyer and the insurance company can call your treating doctors. And if the treating doctor agrees, they can interview them. Okay, so that's kind of very, very invasive. Then the plaintiff also to provide tax records and W-2s and authorizations for all of these things. Now, that you do have to provide if you're claiming lost wages. Plaintiff to provide HIPAA compliant authorizations for various, union benefits and workers' compensation and other sorts of things. I can't even read. It's hard to read. Then plaintiff to respond to all these items in the bill of particulars, like item, it says 3, 9, 11, 14, I guess whatever they felt was deficient. But you see the difference? What I'm trying to illustrate is that the plaintiff's lawyer that was representing this guy just kind of went in there. Maybe they didn't even go in there, but hired a per diem lawyer. You could do that. You could hire a per diem lawyer for like $100 and they'll go to court for you. They don't know anything about the case. They'll just, kind of wing it. But the defense lawyer actually did a good job here. They really sat down, they read their file, they went through the bill of particulars, 1 to 30. This is a little bit insufficient. Let's get number 3, let's get number 4, let's get number 7. And then, see, this is already starting down a very bad road for the plaintiff, because what's going to happen next is if the plaintiff doesn't supplement, like say number 3 or number 11, or doesn't supplement it as well as the defendant wants, guess what the defendant's going to do? Instead of conducting the deposition, they're going to file a motion to dismiss. And, the case isn't going to get dismissed, because then the plaintiff's attorney is going to say, you know what, okay, you don't like how I supplemented number 11, I'll supplement it some more. But then, something else will happen. They'll say, you were supposed to provide an authorization for a prior car accident from 15 years ago. And they're going to say, well, you didn't provide the authorization, or we were not able to get those records. So they're going to make another motion to dismiss. And now the judge is going to say, well, they've already made one motion. Now they made 2 motions to dismiss. Well, now, hey, so something must be rotten in the state of Denmark. Something must be wrong here. It smells a little fishy. Okay, you better provide everything within 30 days. And if you don't, then you'll be precluded, meaning you can't use that evidence at trial. And then, maybe they'll make a third motion. And see, that could lead down a slippery slope, and that could lead to a case even being dismissed or a plaintiff being sanctioned somehow. So it's not good. So what I like to do is, review the file as a plaintiff's attorney and see what you need and put that in the order, because, I'm sure you need certain things, like you need depositions of people with knowledge, you need documents. If you don't have the right documents, you can't conduct the depositions in a meaningful or substantive way because you don't have documents. You're questioning the person, but if you had documents, you would have a much stronger foundation from which to start and question the person even better, right? So these are all the things. So there were like 7 things in here, and I haven't called the client yet. I'll give him a call, I'll chat with him, but it's just interesting because they had, like this motor vehicle accident 15 years ago. First of all, you can't get anything from 15 years ago because they only hold medical records for 7 years. So it's like an impossibility. But it's just like, because the reason they do this is because, number one, they know that they can fight you on all these technicalities, right? Like, you didn't supplement number 11 well enough. You didn't give me this authorization. You didn't give me this record from the Workers' Compensation Board. And then they could paper you to death and they could delay the case. But the other reason they do this is because they're billing, right? They're a big, let's say, insurance defense firm. They're getting paid by the insurance carrier. So look, what would I rather do? I'd rather get paid more. I'm billing like whatever, $300, $500 an hour. So let's bill more. Let's bill for like, they didn't supplement number 11. I don't like the supplement still. I still don't like the supplement. Let's just keep sending letters. Every letter we send is $500 an hour. And it just goes on ad infinitum. And unfortunately, the courts don't really stop it, So you have to kind of like, you have to fight your fight as a plaintiff's attorney. You have to be the one that stops it, because if you don't stop it, if you don't make the motion, if you don't provide the information, and if you don't request and then follow up on the information that you need, then your case could really get destroyed. So yeah, so they had a lot of things in here that I didn't like plaintiff to respond to social media information, social media demands. And see, everything that they were supposed to do, the plaintiff, they have to do within 30 days. So if they're a little bit late, I'm sure they're going to file that motion like we talked about. So yeah, it's just something to be careful with. And the other thing is that the poor client doesn't know anything about this, right? And they shouldn't really. How would a client really, unless the client is really like going into the court system and reading all their court orders? Most clients don't do that, nor should they really. The lawyer should be handling that. But it's just an example of the different, the way a case can go south if it's not being prepared the right way. So it is important to prepare the case. It is important to be diligent. I like to look at the PJI because that tells me what I have to prove. I like to look at that before I step into the courthouse. And, even before I do, when I draft the bill of particulars. And I don't even know honestly what this case is about, because the person just texted me, so I'm gonna give them a call later today. But it seems like some kind of work injury, and I was just I thought this was interesting for everybody to be educated about this, because it says plaintiff to provide 7 items, and all, I mean, some of them are legitimate, but some of them are already covered in the pre-printed template, right? Because it says plaintiff to provide like all medical reports and authorizations. So they're already going to provide that. So why do we have to say it again, that they're going to provide medical providers, that they're going to provide, tax records? That's already in the pre-printed template. So it's kind of like they stonewalled this guy. He probably sent like a per diem. He probably sent one of those guys that you pay them like $100 and they cover an appearance for you, rather than having somebody from his firm go themselves. And then that guy was probably like, okay, I'm getting my $100. I don't care. Write whatever you want. The guy just took like a blank, piece of paper and started writing, like, you're going to give me this, you're going to give me this, you're going to give me this. And now that the guy got stonewalled. So that's just an example of something that you don't want to do as an attorney. So I hope this was helpful. Let us know what questions you have, and we are here for you. Okay, have a great day, everyone.